communicated that to your client in terms of is that to correctly summarize the plea agreement or the potential plea offer, I should say?
The only change was that he wasn't aware of the concurrent status for the second case. At this time, though, he still maintains a not guilty plea.
Sure.
Respectfully rejects the offer, and we announce ready for trial.
Okay, Mr. Mender, I'll tell you and I'll tell Mr. Beebe and Mr. Stevens the same thing, okay? At this point, you have the absolute right to plead not guilty, and that's what the law will presume, and the court will, of course, instruct that you have a presumption, as the presumptions and protections you enjoy as a criminal accused. You have to decide for yourselves what you want to do in this particular case, depending upon the results or the outcome of the trial. The only thing I would tell you, Mr. Mender, is the most, and I'm sure that Miss Fagan, she is a very fine attorney. Seen her work. But trials, there's one thing about trials, it's uncertainty. You don't know what's going to happen. So you got to beat 4 counts.
Welcome back to the channel. What is going on with the scandalous Judge Glanville? If we only knew what we knew now back then, I'm sure this gentleman wouldn't have took a plea deal. But it is what it is. He is now a witness for the state. The next witness up is mounktounk Sledge. He took a plea deal, and it seems to be coerced by Judge Glanville. Let's get straight into it. Please hit the like button, please subscribe, and thank you for tuning in. Let's get it.
If you don't beat them, what will happen is, under this A&C recidivist statute, I have to, under the law, sentence you to the maximum sentence. And then whatever I sentence you to, you serve to the door. That's not, it's not anything because I don't like you or because of what you're being charged with or whatever. Those have nothing to do with anything. That's what the state of Georgia, the legislature has mandated that I sentence you to. So one of the things a plea does is you know what you're getting. It caps your exposure. So, and what the state's telling you today is if you take the plea today, this is what you're going to get, and this is what I probably sentence you to, and you're done. You got to decide that for yourself. You can't be worried about any of these other folks that are attached to this indictment, because a plea is individual to that particular person for those particular reasons that he or she feels is of best interest to them, not anybody else. So if you want a couple minutes out to talk with Ms. Fagan about that, nobody will be the wiser, and certainly, but if you don't wish to do so, that's fine too. You'll get the fairest trial that the law demands and expects you to get. You will get that. I, as your trial judge, will make sure that that occurs. But one of the things I cannot do is I can't force the state at the end of trial to pull this recidivist notice. If you get convicted, they can maintain it and you'll serve every day of it. And Ms. Fagan can ask them to pull it and they can say no. I can't make them do that. So you've got a lot to think about. So I'll give you a few more minutes to ponder that, because that is, when they file a recidivist notice, they have basically, in poker terms, they've called. Like, what do you want to do? So I'll let you think about that and you can let me know, and if not, then we'll see you next week for trial. All right, we're on the record in the matter of the state of Georgia versus Antoniosledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, counsels Love and Hilton. Okay, counsels, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right, Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so be God or so firm?
Yes, I do.
All right, you put your hand down, sir. All right. Mr. Sledge, over the next several minutes, what's going to happen is we're going to go through such a thing called the provincy inquiry. So basically, in our system of jurisprudence, we don't force people to plead guilty. So I have to be assured you understand your constitutional rights and that you freely and voluntarily waive those rights so I can go ahead and sentence you. The second thing it does is we go through a factual basis, and I determine there's a factual basis that the state would have been able to prove in this case beyond a reasonable doubt had they tried the case. So assuming that I find that you understand your rights, we call it the Boykin inquiry. And then the second thing is, then I find that there's a factual basis I can accept your plea. So, ladies, which one of you is going to do the plea?
I am here.
All right. Miss Love is going to go and ask you a series of questions in just a minute. And then your attorney, Mr. Wright, will follow up with that. And then I'll ask you a couple of questions, and I should be able to sentence you in accordance with the negotiated plea, okay?
Yes, sir.
Okay.
I want you guys to take notice to Judge Glanville's voice. You can hear the excitement in his voice that this gentleman is taking a plea deal. But I also want you to take notice to Antonio's body language. To me, it looks like he's ready to cry. I don't think he really wanted to do this, but hey, sometimes you have to go with what your heart is telling you. Now, what I mean by what his heart is telling him, I believe he does not want to testify for the state. But I guess he just felt his back was against the wall. I'm not sure what is really going on with him, but it is what it is. He's now a witness for the state, so let's continue.
Miss Love, whenever you're ready, madam.
Thank you. Mr. Sledge, please state your true, correct, and legal name.
Antoniosledge.
And are you the same Antoniosledge, also known as Mounk, who is listed in indictment 22SC1882?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that the minimum sentence for conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act is 5 years and the maximum is 20 years in prison?
Yes, ma'am.
Do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon, as in OCGA 1611-133, is 15 years in prison.
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty?
Yes, ma'am.
Which means that the state will recommend to the court the following sentence.
Yes, ma'am.
As to count 1, 15 years to serve, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today, but that the state is not recommending either?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea involves your being placed on probation, and that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence? Do you understand that?
Yes, ma'am.
Do you understand that you are not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice given to you by your attorney or anyone else?
Yes, ma'am.
Do you understand that if at any time you are sentenced to confinement based on this sentence, neither the court, your attorney, nor the district attorney's office has anything to do with parole, and that in that circumstance, the Department of Corrections or Board of Pardons and Paroles
Yes, ma'am.
are the only persons who can address parole, and that no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and your right or ability to obtain employment. Do you understand that these rights may be affected?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of another felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to try by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you are giving up all of these rights?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Now let's get into the evidence that they have against him.
Stop putting me on fucking fake pages, cause I don't give a fuck, man. What y'all say, what y'all do. Anybody want to see Mounk? I'm here. I don't hide, and I do not run for fuck niggas. You did.
Your Honor, this is relevant, and we would seek its submission for at the. You hear the comment, but then at the bottom underneath the photograph, it has nah, FR, for real, 100, 100. And then the two little green snake emojis.
Yeah. Which are
We
alleged to be a YSL gang symbol. Okay.
Yes.
Yeah.
We've already admitted the content, the group photo that is now labeled States 405 Yankee, but because of what Mr. Harvey pointed out, that we had taken out comments, I was not certain without looking back at it whether the YSL, FUXK, the rest love had been admitted, and for that reason I sought to admit the whole post since this is the witness that made
Okay.
This is a similar social media post.
All right. So I'm gonna basically rule generally, unless you think that there is something particularly, oh gosh, I think that there's gonna be some other kind of relevancy or 403 objection to something. The posts that are just seeming to show his posting about gang life or indicating gang insignias or anything like that.
You can lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
That's it. There's a word he uses, but yes, that's the extent of that video. On the screen is the post. Oh,
I just don't know what the relevance is of some of these things. Like,
Mr. Harvey, you wanted to say something.
Yes, one other point, Judge. With the previous exhibit and this exhibit, we previously had a ruling and discussions commentary on these.
Oh, I can't even see that because of what's on my screen. But yeah, we don't, I mean, I don't think, unless the comments are relevant, let's not have those on there.
So,
Now, sometimes the comment might be relevant.
But we don't know who's making the comment. We can't cross-examine the commenter. And we have had Judge Glanville rule that the comments come out previously.
Okay.
Who is this that's commenting? 70 likes, one comment.
Okay.
You know, come
All right. So, I agree with the prior ruling, and I don't know that this is how you were going to present it on the stand when you use it. This just may be how you got it now. But make sure before it shows up on a screen with a jury that whatever limits have been placed on this, you abide by them. I mean, I saw the slide from the opening that had something on it that had been specifically talked about and ruled that you had better not in any way put that before the jury. And lo and behold, it's up there on the screen. Not going to get back into it, but that should not happen again.
Where Mr. Sledge is saying free Jimmy Winfrey and FUXK12 and KANT hold the real one down. And he tags Mr. Williams on the left side.
Right.
So this is absent the comments on the right. This is the post that we would.
All right. And do you already, if you already have that as an exhibit number, you can tell us now. Otherwise,
It's Space Exhibit 401 Yankee.
okay.
And the exhibit number.
His jail call, I've listened to it. It's essentially him. He had a preliminary, he was charged with the murder of Donovan Thomas by Detective Thorpe. The state has since determined that he is not responsible. He had a prelim where no probable cause was found. After the prelim, he calls his significant other. I'm assuming it's his significant other. It sounds like it from the context. And he basically talks about the testimony at the prelim. He speculates about who witness 1, 2, and they used codes in the prelim, witness 1, witness 2, witness 3. He speculates about who that could be. And he basically says, it sounds like witnesses 1, 2, or 3, and or some combination of within those 3 people really threw Shannon under the bus.
Okay.
So he's commenting, he's speculating, he's commenting about testimony he heard from what witnesses told the detective, and is just giving his commentary. It sounds like people really threw Shannon under the bus. I have no idea why anything from that phone call to his significant other would be admissible in this trial.
Now, it seems to me Antoniosledge would have been better off going to trial. The evidence they have is only Instagram posts and a few Instagram videos, but nothing in reference to murders, robberies, or anything of that sort. No witness, no guns, and so on and so forth. But let's get into the bombshell that's going to hit the state next. Let's continue.
Your Honor,
Yes.
may I bring up another potential issue?
Yes.
So, it's my understanding and belief that that there may be some outstanding Brady material regarding Antoniosledge.
Okay.
Brady to include impeachment.
Okay.
My understanding and belief is that the state may have met with Mr. Sledge and he may have said some things that would fall under Brady in a prior meeting with the state. I'm not asserting that as fact,
Okay.
but I am inquiring about that.
All right,
There was
can
a
you-
prior meeting with Mr. Sledge
Okay.
at a coffee shop.
All right. Was there?
He is, Mr. Shart is correct. I was at the meeting and an investigator, Lancico was at the meeting. There was nothing that I took to, I'm going over in my head everything he said. I
Okay.
didn't say anything. I don't know what. part of that
Okay.
meeting
So,
occurred.
do you two want to huddle together and maybe Mr. Shark can share with you what he thinks got said, and then you can confirm or.
Yes, would the court give us a moment just to step outside now, or do?
Sure, or you can.
I don't know what was said.
Okay.
I don't know specifically what was said.
So do you have any reason to believe Brady material or impeachment material was shared then? Or you're just saying they had a meeting and so there may be Brady material that stemmed from it?
My understanding is that there may be Brady material.
That stemmed from it, but you don't know what it was.
If I knew what the Brady material was,
Okay.
then I wouldn't have an issue.
Well, since there, Mr. Sledge's attorney was present at the meeting, so if Mr. Sharp has spoken with him, or I don't know where the idea that there was Brady material, there's no privilege. So Mr. Sledge's attorney is a ready source of everything discussed at the meeting.
All right, maybe would Mr. Sharp, would you be willing to share privately with somebody on the defense? Do you have the same issue with talking to Miss Love that Mr. Steele does?
I don't.
Okay. Would you have an issue with sharing with her maybe the source of your information? And if you do, that's fine. But
I prefer not to.
okay. All right. She seems a little in the dark on what might be. I mean, I don't think he does either. Apparently, he got some tip that Sledge may have provided Brady material, and that's about all you know. Is that right?
If there is anything inconsistent with what Mr. Sledge has signed in his plea agreements or anything or said before, that would be
That would be
considered
impeachment and therefore Brady. Yes. So you have reason to believe that he may have said something at the coffee shop inconsistent with something he already said.
I'm
Can
asking.
you be more detailed with regard to which thing it might be inconsistent to, or you just don't know?
I don't know,
Okay.
and that's why I'm asking.
Okay.
There were four people in the meeting. If anyone's recollection of those set of events are different than mine, I'd like to know what they are, because mine is not that he said something inconsistent. And as I said, the people who were there are me, Mr. Sledge, Lieutenant Lancico, and Mr. Sledge's attorney throughout the entire time there. So,
All right. Well, it's really the relevant issue is not who was there. The relevant issue is, did Mr. Sledge say something inconsistent at the coffee shop with some whatever he has told the state or law enforcement previously? I guess any of those four people could sort that out. The best two would be, well, the best one would be you if you were the prosecutor there, because I mean, I don't know what else to say. Maybe there's nothing, but maybe if you've got notes, or you and your investigator get back together and think it through and try to figure out whether he said anything that's inconsistent. And I mean, that's or what else to do.
I know. So, we will search our collective memory.
Okay.
I am really interested in speaking with Mr. Sharp about what he is talking about so that I can understand where.
All right, I'm not sure he knows.
Different. So,
If the word bull crap was a person, it would be Miss Love, the prosecutor. She's full of crap. Let's continue.
somebody has said the word Brady or something, and I don't. Well, I will talk. We will.
Okay. Something inconsistent.
Did anybody take notes? I mean, we had 4 people there. Nobody took notes. Nobody.
I don't know that we know that. I don't know.
No, I'm asking. We're entitled to it if that's what happened. So the answer is,
Hang on. Mr. Harvey, talk to me. Don't talk across to opposing counsel.
I am just somewhat astounded that we had 4 people meet at a coffee shop and nobody took note number 1. Nobody,
Mr. Harvey, no one has made that assertion.
nobody recorded it. I'm asking if there was a report, if there were notes taken, if there was a recording, we would have something to review to determine whether or not there was something that should be provided to us.
Okay.
Okay?
I don't know whether that happened or not.
I would, if I had I did not record our inner meeting, our conversation, because I would have turned that over. I did not record our conversation.
Okay.
It was literally a conversation.
Right.
And that's it.
Okay.
So I missed it. I understand then that not any notes of that meeting.
So I don't know if Ms. Love can speak to what Mr. Sledge or Mr. Sledge's attorney may or may not have done.
I'm asking from the state's obligation to provide it to us. We don't have to go.
I understand.
All right. So I'm just inquiring as to whether there are any notes, and I'm just surprised. Well, I would like an answer as to whether or not any notes
Were taken.
Thank you.
2 things. No, I did not take notes. I talked. Lieutenant Lancico, as she sat there, she looked around and listened and looked around our surroundings. We were not within Fulton County.
Okay. So no notes?
No.
Sorry. No notes.
I would not. Well, there are no notes. I did not take notes. She did not.
Okay.
My notes are not. My notes. My investigator's notes would be something to which either of the defendants would be entitled. My notes would not.
Brady that you hear, then you need to reduce it to writing and provide it. We talked about this before, you know that. And so you are maintaining that no, you didn't take any notes, no, your team didn't take any notes. As far as you can think right now, nothing Brady impeaching was said. You will give it some further thought along with your attorney.
Sure. Make sure that
Okay.
his memory was mine.
That's all we can do at this point. Thank you for raising it so that they can think about it some more.